Good morning, everyone. With the permission of the Learned Director, I, on behalf of Sikkim Judicial Academy, would like to begin today's session on Role of Executive Magistrate in the Criminal Justice Administration under Code of Criminal Procedure 1973. To conduct this session, we have among ourselves the most dedicated and esteemed resource person, Mr. Khatiwada, Learned Registrar, Judicial Service and OSD, to Honorable the Chief Justice, High Court of Sikkim. May I now request the Learned Director to kindly offer Khada to the Learned Resource Person. Thank you, sir. May I now request Learned Director, sir, to kindly give the welcome speech, sir.
Good morning to everyone present here. To grace a wonderful session of today's program, we have benign presence of Learned Registrar, OSD to Honorable Chief Justice Mr. Prajwal Khatiwada, as a resource person, who, despite of having heavy pressure of engagement and busy schedule, has been kind enough to accept our request and come here today and to conduct this session. I, on behalf of Sikkim Judicial Academy, would like to welcome sir in this practical program. I equally would like to welcome our Additional District Collector West, Assistant Collector East. I don't think it's necessary to share any information. Our Learned Resource Person joined initially as a member of Sikkim Judicial Service in the year, I think, 2005. Then reached up to the cadre of Sikkim Judicial Service and worked as a Principal District and Session Judge till 2022 before July East. Then posted presently as Learned Registrar, Judicial Service comes OSD to Honorable Chief Justice. And duly considering the length of service and experience, the Honorable Chief Justice has been pleased to nominate him as a resource person of today's program. And now, without further delay, I would like to hand over this platform to the Learned Resource Person with the request to kindly proceed with the session. Thank you.
Thank you very much, Director sir. Very good morning to the three eminent participants. I think sir, let's attend on back. Sir, it was on land acquisition or something. Some topic. I remember sir like as it is. I know sir also. Otherwise also, sir and our new executive magistrate. I met him recently. As you can see, role of executive magistrates. First of all, you all know that in states like Arunachal Pradesh, Mizoram, and probably some places of Meghalaya. Meghalaya, there have been some recent changes, but till very recently, it was the executive magistrate who was performing the judicial functions, quasi-judicial as well as judicial functions under the CrPC also. And Arunachal Pradesh and Mizoram, I believe still, most of the functions, they have still not bifurcated. Still few offences, they have graded those offences, are still being tried by executive magistrates. Now that is your, I would say, that is your role under the CrPC. And it is necessary that you have a good, what can you say, you are well aware of all those provisions under in the CrPC which provide for, which lay down your powers as well as functions. Powers, I won't insist much. I would say it's basically everybody's function, including the courts. Different parts of CrPC, sir, there are different chapters and all. Few chapters at some places provide for executive magistrates. And before we proceed further, if I could ask, I'll start from sir. Till date, sir, after you have assumed the role of a magistrate, be it subdivisional magistrate or additional district magistrate, Khatiwada, in how many cases have you had the occasion of referring to the CrPC, sir? Sir, what is start going, sir?
Good morning, everyone. Good morning, sir. Sir, since I joined subdivision magistrate, Kavi, in 2019, since then, sir, अहिलेसम्म सर मैले चाहिँ त्यस्तो खालको हामीले युज चाहिँ त्यस्तो गरेको छैन अहिलेसम्म हजुर CrPC त्यस्तो ल्याउनु परेको छैन किनभने सानो जग्गा छ सर त्यस्तो खालको त्यो आएको छैन हजुर आएको छैन हजुर
So, having assumed just 2 months back, so I'm not happy liberty and privilege to have such case referred to me, or rather I have referred to the court that way. So far we have only been busy. Yes, petty civil matters are there, but yes.
Okay, sir. And you, sir? You have not had the occasion. Now, what I will do is, since practical aspects, about even theoretically, practical aspects also, since none of the learned magistrates here, learned executive magistrates here, has had the occasion to deal with these provisions, what I'll do is, I will go threadbare through those provisions, and I'll try and explain few judgments also I can defer to, though you might not require those judgments. Had this been a session for the judicial magistrates or chief judicial magistrates or even session judges, then case laws would have come handy. But for you, case laws might not be handy, but the principle enunciated in those case laws I can always discuss. That will be handy for all of you. Isko jod dijiye. Now, before the present CrPC, as you all know, we had the old CrPC. Everywhere under the CrPC, you will find reference to the previous CrPC. The previous CrPC was Code of Criminal Procedure 1898. That was the British law on the subject, procedural aspect. Now, if we compare these two laws, the CrPC 1898 and the CrPC 1973, what we will find is most of the provisions of the previous CrPC have been reproduced in the present CrPC also. And the remarkable difference is, sir, under the old CrPC, it was you as the executive magistrates who wielded diverse functions and powers under the CrPC. And right now, as I said, barring few states in the northeast, they have bifurcated it. And very soon, look, in any case, it has to be bifurcated. Because for applying the CrPC, you will have to apply other laws as well. You can't apply CrPC in isolation. For example, 144, public peace, public disturbance, if something has been at 144, 145, I'll discuss those provisions threadbare, sir. You will have to obviously know the provisions of the IPC. Then other laws, for example, under SADA, Sikkim Anti-Drugs Act, the learned magistrates have their own, I would say, a very important function. Equally under the NDPS, Narcotic Drugs and Psychotropic Substances Act 1985, under the Essential Commodities Act 1955 maybe, most of the laws providing for criminal sanctions or criminal punishments, you will see that some role has been attributed to the learned executive magistrates. That is your, I would say, pivotal role. Under all the criminal legislations, the learned executive magistrates would have a pivotal role, or I would say, very important role, based on which the whole of the criminal law would be set into motion in future. The criminal law itself would be set into motion after your intervention. I'll discuss those provisions, though ours is only under the CrPC, but I'll briefly refer to those SADA, NDPS and Essential Commodity Act. I'll briefly refer to this. I won't take much time also because I know you are very busy people. As a funny, since most of the magistrates, I know them personally, I know that had they had time to attend today, they would have certainly come. Now, starting with our CrPC, I'll just try and bring the relevant provisions here. Now, as you very well know, CrPC, Code of Criminal Procedure, or some people would also call it Criminal Procedure Code. But actually it's Code of Criminal Procedure 1973. But the usage has been Criminal Procedure Code. खासमा चाहिँ it's Code of Criminal Procedure 1973. त्यस्तै पाराले Code of Civil Procedure 1908. Now, if we look at the purpose of enacting this particular legislation, you would mainly find two important things. Firstly, the whole purpose of CrPC is to lay down the procedures for maintaining public order, maintenance of public order, public peace, prohibiting or removing nuisance. That is the whole purpose. One part of CrPC, the purpose would be that. For example, even for assisting the courts under 82, 83, sir, I'll discuss that also, which might come handy to sir, especially sir who is posted in Gangtok, because we have many 82, section 82 criminal procedure CrPC proceedings. 83, attachment of property, which is more of a civil function. And I'll also talk about areas where we have gone wrong. General mistakes, frequently mistakes, and which vitiates the whole proceedings. The other role of CrPC is to, firstly, paramount object, somehow maintain public peace, tranquility and order. Other function is to lay down procedural law for the courts, for the criminal courts to try a particular person who is an accused before it. Acha, I is it clear? Sir, is it clear from here? क्लियर गर्न सक्दैन लाइट एउटा अफ गरेर हुन्छ सर स्क्रिनमा हेर्नुहोस् सर The act may be called the Code of Criminal Procedure 1973. As I said, people call it Criminal Procedure Code. CrPC is the acronym or abbreviation. 1973. Previously we had 1898. यहाँ refer पनि गरेको छ. Most of the sections have been reproduced, but keeping in view the present scenario. Now, if we look at the definition clauses, now these might not be very relevant, but just to start today's session, bailable offences, I need not go into that. You will be dealing very less with bailable offences. Cognizable offences, yes, you have to remember, cognizable offence, any offence in which the police officer may arrest someone without warrant. All serious offences, 302, 376, 302 is murder, 376 rape and all, even 326 grievous hurt cases. So I just to give you a brief, lay down brief sketch plan. Then sir, inquiry. This is in section 2, clause G. I want you to take note of this. Inquiry, now this is where your role would subsequently come. Inquiry means every inquiry other than a trial conducted under this code by a magistrate or court. Now the best part under this present CrPC is magistrate. They refer to two kinds of magistrates. इसको सब नोट कर दीजिए, सेक्शन 2G. सेक्शन 2G इंक्वायरी का डेफिनेशन. Inquiry means every inquiry other than a trial conducted under this code by a magistrate or court. Now your inquiry would be under 174, limited inquiry under 144 and 145, under 82, 83. I repeat, the role of the learned executive magistrates, so far as inquiry under the code, so it's called code. When we talk about CrPC, CrPC means Criminal Procedure Code, Code of Criminal Procedure, CrPC, and or the code. Code but means the 1973 code means interchangeably used. Now when you look at this, is it clear? Sorry, दिख रहा है आपको? नहीं दिख रहा ना? तो अंदर clear work बच्चों. ये चाहिए भाई? So I got a better one. So you देख लो कैसा वाली? Yes. Inquiry means every inquiry other than a trial. Now let me point out at the outset, you are not to conduct any trial under the CrPC. Trial is only before the criminal court or the judicial or the chief judicial magistrates, not executive magistrates. Of course, there are few laws under which you can conduct it a limited trial kind of thing, but ours is a country where the adversarial system of conducting trial, where two parties would be there, can only be done before a court of law, which is the criminal court, not the learned executive magistrates. So your role under the code would be mainly confined to inquiries. That is why I wanted to make it clear that inquiry would mean every inquiry under the code, not including a trial. Trial can only be done by us, not by the learned executive magistrates. Your first thing I wanted your honors to know. Investigation. Immediately after inquiry, 2G ko baad mein 2H ma, they have defined investigation. No, investigation. You might per se or you might by yourself not conduct an investigation. But you will be a part of the ongoing investigation. How? Under section 164 statement, dying declaration under 32, Evidence Act, I'll discuss those provisions as well. You will be part of the, at times, TI parade, test identification parade, jail ma, to 10 jan ubayar sir, test identification parade, when the judicial magistrate is not there. And the best part is, the state of Sikkim has issued a notification in consultation with the High Court, saying that when the judicial magistrate which includes the Chief Judicial Magistrate in this particular case. When the judicial magistrates are not there in station, then you will be deemed to be judicial magistrates. You understand, sir? In most of the states, this particular notification might not be there. And this was issued long time back. So if let's say I am in Namchi, I am a judicial magistrate posted in Namchi, I am not in Namchi, I have come to Gangtok or have gone to some other place. And if an arrest takes place in Namchi, र सरहरू त्यहाँ as magistrate भन्दा सब ADM पनि आउँछ. The notification clearly says ADM also. I'll try and circulate it somehow by today evening. You will deemed to be a judicial magistrate under the CrPC. So by virtue of that, you can remand an accused who is produced before you for 7 days. After that, to judicial custody, it has to be a judicial magistrate or a chief judicial magistrate. This is what the two things: inquiry. You have to keep that in mind. You are to only do an inquiry under the code and not a trial or other proceedings. Investigation, yes, you have a role. You have a major role in different investigations, but you can investigate yourself. You can be a part of the investigation. These are basic concepts I wanted your honors to understand. Now, judicial proceedings. There is something called, there is a terminology called judicial proceedings. Now, it includes any proceeding in the course of which evidence is or may be legally taken on oath. Now, a proceeding before you under the 144, 145 could at the most be quasi-judicial. It cannot be a judicial proceeding because you are not taking evidence under oath. Oath or affirmation. Here, there is a difference, sir. Court में जो पनि आउँछ, either you administer oath, so somebody could be an agnostic. म त कसम मान्दिनँ, मैं कोही धर्म नहीं मानता हूँ, म त केही उते गर्दै भगवान मान्दिनँ, कसरी म भगवानको कसम खानु भन्दैन. That is why they will say oath or solemn affirmation. Sir, बुझ्नुभयो? This is a difference which very people tend to ignore. There could be a person before you. Of course, you will not be administering oath, but just for your information, oath and solemn affirmation. Indian Oaths Act, Samre. We have our own Indian Oaths Act. It distinguishes between an oath and a solemn affirmation. So this difference also kindly note. And judicial proceedings. Why I have referred to judicial proceedings is any proceedings in the course of which evidence is or may be legally taken on oath. You will not have the occasion to take evidence under oath. It is only for the criminal courts. Yes, under certain circumstances, maybe on your civil side, few affidavits may be sworn before you. But that will not be a judicial proceeding because then there is nobody in contention. Duita party cha, they have adversarial interest, only then judicial proceeding. That could be some other proceedings, an affidavit co-proceedings. It is some proceeding but not a judicial proceeding. So these key words, that in magistrates, these key words तपाईले note गर्नुहोस्. Inquiry, trial होइन, only inquiry. Investigation, yes, limited role. I'll talk about those provisions. Then yes, proceedings. You would be conducting few proceedings, but not a judicial proceedings. किनभने under oath, only a criminal court, that is to say, the London judicial magistrates and the London chief judicial magistrates, or बाहिर state हो भने additional chief judicial magistrate, additional district judge, additional sessions judge, assistant session judge, and session judge as well. Only they can take evidence, they can administer oath in a trial. So only the proceedings before them would be a judicial proceedings. Now, why I am saying judicial proceedings? The reason why to distinguish or coaching, whatever we do during a judicial proceedings, we are protected. Sir, whatever we do during our proceedings before a court, we have, at least for us, we have Judges Protection Act. For you, Section 21 or in good faith Jotha, protection of government servants or public servants, that provision would come. That protection will be there if you are acting in a judicial proceedings. That is why the difference is very important. Then, other, I did not go. Public prosecutor. Public prosecutor means any person appointed under Section 27, includes any person acting under the direction of a public prosecutor. Now, why I am referring to a public prosecutor here is, sir, in the court, representing the state would be the public prosecutors, additional public prosecutors, assistant public prosecutors. And these public prosecutors are also assistant government advocates or government advocates. Now, as in your role as executive magistrates, you will be frequently coming across these public prosecutors. Sir, Vaishnava? That is why magistracy and public prosecutorship is interrelated. For example, Sarko, while sitting as additional district collector or sub-divisional magistrate collector को company civil company हेर्छ सर, land को matter छ, obviously court मा case आयो भने you will be represented by the concerned government advocate or the assistant government advocate, who are invariably the public prosecutors also. That is why this terminology भी तपाईले याद राख्नु पर्यो. Sub-division को definition I did not go. Then सीधे म लन्डन मेजिस्ट्रेट्सहरुको this is not relevant. So this is the only provision in the CrPC 1973. Please note this is section 3 subsection 4. 3 bracket of 4 लेख्दा हुन्छ. Section 3 brackets of 4. Now many law students, law scholars, judicial officers, law students have asked me, sir, it is so confusing. Under the CrPC, they refer to magistrates interchangeably. Oh, what roles are to be assigned to executive magistrates? What roles? Now, executive magistrate would include everybody, including the district magistrate ko under. And what is the role ascribed to a judicial magistrate? Everybody, you will get confused. So, Section 3, subsection 4, I just want you to, I'll read it out then, sir, so reflect on it. No, I'll just read it out. Where, under any law other than this code, The functions exercised by the magistrate relate to matters which involve the appreciation of shifting of evidence, or the formulation of any decision which exposes any person to any punishment. Punishment can only be after trial. That is why that difference, inquiry and trial, or penalty or detention in custody, pending investigation, required or trial, or would have the effect of sending him for trial before any court. They shall, subject to the provisions of this code, be exercised by magistrate, by a judicial magistrate. This is for judicial magistrates, which will obviously include chief judicial magistrate and then so on. Secondly, relevant to you, sir, relevant to all learned executive magistrates, matters which are administrative or executive in nature, such as granting of a license, suspension or cancellation of a license, just Arms Act ma huncha, sir, sanctioning a prosecution or withdrawing from a prosecution, they shall subject as efforts to be exercisable by an executive magistrate. No, other than this code, like I said in the beginning, that is why I purposely uttered few words in the beginning. This is only for procedural aspects. Code of criminal procedure. This is not a substantive law, like the IPC or the Transfer of Property Acts or CrPC does not provide for anybody's rights and liabilities. It only provides for procedures by which such rights and liabilities are determined. On the area of procedural, CrPC is not a substantive law, only a procedural law. And all by virtue of section 4, IPC ma you will apply CrPC, Essential Commodity Act ma you will apply CrPC, POCSO ma wherever your role is, and I will tell you where your role comes. Here also you will use CrPC. That is why it is essential that we know our differences, and this is the only provision which actually demarcates it. After this, you will have to gather from the wordings. They will refer to as district magistrate, they will refer to as executive magistrate after this. So, you certainly yaad rakho. Then others I don't know. इसमें तब कितनी relevant चाहिए ना? Oh, okay, so I was saying in Arunachal Pradesh and Mizoram, that section, instead of that section under the CRP, this section should be read there. This has been incorporated there. In its application to Arunachal Pradesh and Mizoram, after subsection 4, the following subsection shall be inserted, namely, not any reference to the provisions report to apply in a court of session or chief judicial magistrate, the district magistrate गर्छ. हेर्नुस् सर, magistrate or magistrate of the first class or judicial magistrate of the first class, executive magistrate. In those two states, and this is still the situation there. Meghalaya, it has gone. Arunachal Pradesh and Mizoram, sir, हेर्नुस् त. So you are performing as executive magistrates in those two states. You are performing the roles of magistrate or about the magistrate first class मा थियो. पहिला second class, third class हुन्थ्यो. Under old CrPC, we had judicial magistrate first class, judicial magistrate second class, judicial magistrate third class. But under this new 1973, we have only judicial magistrate of first class. Somewhere some reference to second class has been made, but it is obsolete. हुन्छ सर? Yes, sir. So, सुरुमा मैले भनेको in this day, that is why it is important for you to know CrPC by heart. अच्छा भाइ नेक्स्ट टाइम चाहिँ क्लियर गर्नुपर्छ ल. अब उहाँहरूले देख्नु पछाडिको देख्दैन ल. अनि के उपाय निकाल्नुपर्छ कि मेरो प्राय यसमै गर्छु म हो. So this is the provision which says that all offences under any other law, including the IPC, the procedural aspect will be governed by CrPC. Section 4. Now I will straight away go to अच्छा सर यो पनि classes of criminal codes. besides the High Court and the courts constituted under any law other than this court, there shall be in every state the following classes of criminal courts, namely Court of Session, Judicial Magistrate, Judicial Magistrate, second class को reference one है sir. ये है लेकिन as of today court चाहिए ना sir, ऐसा court नहीं है. And executive magistrates, this will not include district magistrate. He will assign the case to you. Now what will the executive magistrate do? Police challan cases, few offences under the Essential Commodities Act, under the Sikkim Police Act, you will have few roles, and there probably you can also try that particular person. Traffic challan violation cases. Now what happens is, now this has been there since 1973. Other laws were also there in and around 1973. Now with time, all those other laws have undergone sea change. So बिस्तारी executive magistrate को role हटाको छ. But in the 1973 Act, you will still have this. And few acts such as Maintenance of Welfare of Parents, something act, you will still have those functions. No, you certainly have that. Then I will straight away go to section, what can you say? Where your expertise is required is sir, section 44. Now you have the power to arrest. As executive magistrates, sirs, you have the power to arrest. This is a very, we cannot arrest. I am principal session judge, I cannot arrest, sir. But you can arrest. Judicial magistrate first class, chief judicial magistrate cannot arrest. They can direct someone to be arrested. And here also, sorry, judicial magistrate is here. I'm so sorry, judicial magistrate is also here. This solemn function, session judge cannot arrest. Only executive and judicial magistrates can arrest. I will rephrase my sentence. Sessions judge, assistant session judge cannot arrest, sir. Only you and judicial magistrates. And I'll just read it out. When any offence is committed in the presence of a magistrate, whether executive or judicial within his local jurisdiction, he may himself arrest or order any person to arrest the offender and may thereupon, subject to provisions wherein contained as to bail, commit the offender to custody. Second, subsection 2, any magistrate, whether executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. So this solemn function, this critical function, I would say you have to be very careful, has only been given to the police, executive magistrate and the judicial magistrate. But your condition is, sir, two conditions here, no, sir, under which you can arrest. First condition is where the particular offence has been committed in your presence. Sorry, Anubhav? When any offence is committed in your presence, for example, sir, sorry, on duties within your jurisdiction, that's the main thing, sir. Sorry to Janu, for example, sir, you are going to, let's say, you are going to Gangtok market. MG Mark ma sorry room, sir. Now you see one person, proxy khayera lady like जिस्काउँदैछ, स्टक गर्दैछ, हातपात गर्दैछ. So you got my point? He's trying to rough up or molest a lady, female, or a child. It is an offence. These cases. What is this? By constable, come here. Please take him into custody. Something like this. That is one condition. If the offence is committed in your presence. Second condition, overall, even otherwise also you are wrong. Second condition is, at any time, arrest or direct the arrest. Direct the arrest means constable le bola, please just take him to the thana, I will come there one day. Now, second condition is, even if the offence is not committed in your presence, but you know that this person is involved in a, okay sir, warrant case, sir, cognizable case and warrant case. Involved in a cognizable and a warrant case. Warrant case is, sir, I think I skipped warrant case at that time. Cognizable case to certainly anyway where you can arrest without warrant. There is something called warrant case or summons case. Warrant case is if the offence is punishable with imprisonment which is more than 2 years. It's a warrant case. So you can arrest him or direct his arrest without warrant. But if it is a summons case, those 2 saal is the punishment. For example, peeing in public. Jhora like Mahila garnu, some of these Jhora and all, or natural streams. Mahila garbage factories. These are non-cognizable and summons cases. Mostly they would be punishable by fine or 1 year imprisonment. That is a summons case. You cannot arrest. The warrant case, okay, I'm so sorry I skipped it. So, if you know, and as magistrates you will be knowing, in 2005 when I was judicial magistrate and our Telang sir was the district magistrate, he was aware of many Arms Act cases in which he had given sanction. And accused would be kind of bagger, beat ser, and we used to coordinate. Aajkal coordinate sahi nahi, sir, with all due respect. At that time, there used to be one district magistrate, ADC Untola sir, SDM. शायद one DC एक जना, ADC 2 जना होला, एक जना होते sir, and SDM would be 2, at the most 2 SDMs. Now we have SDM headquarters, SDM protocol के Untola sir. So at that time, 2005, Mr. Telang would be knowing that particular accused. I as judicial magistrate would also be knowing that accused. So you know that अरे यो तो भागी ना कुछ, इसको खिलाफ तो warrant has been issued by the court and I know him. You can cause his arrest. And I'll tell you, there is a provision. Whenever there is a criminal trial and it ends in a conviction, do you know that, sir, magistrate, do you know that the sessions court has to send a copy of the judgment to the district magistrate? In Sikkim, I started it long time back. Though it was already in the provision since 1973, a copy of the conviction and that judgment has to be sent to the district magistrate. Even today, POXO cases we don't send normally. Or if POXO cases, POXO you know sir? Protection of Children from Sexual Offences. POXO cases we strike out the name or we redact it and then send it. At least I have been following it. And I doubt very few are following. Why those copies are being sent? So that the district magistrate, who is again the administrative head of the executive administrative head of the district, so that he knows that, hey, this is a convict fellow. All address of it, sir. So the district magistrate is bound to know. He is the boss of the district. That is why a copy of the judgment, and that provision is in CrPC only. Before winding up, I will show you that provision. Copy of the judgment has to be sent to the district magistrate. He will mark it to the other executive magistrates. And you can maintain a file. I'll give you an example, sir. There is one person No, his name is K. Chetri. I would take his first name. He is a driver. I convicted him for rash and negligent driving in 2006-7. Another case, rash and negligent driving with 304A, culpable homicide not amounting to murder, that death by negligence. सिङतामको पुलमा एउटा प्रधान केटाले त्यही गाडी लिएका, त्यही सेम के क्षेत्र, convicted again. Can you believe, sir? Even today he drives a taxi. How can it be allowed? How is it that his license is still valid? That shows lack of coordination between court, DC or district magistrate office and motor vehicles department. Certainly, that Mr. K. Chetri, twice conviction. I know because I have convicted in both cases. Stayed in jail for 2-3 years. अब गाडी हिकाएर मार्दा 2 years मात्रै त्यो टाइम छ. No, probably it has gone up. He is still driving a taxi vehicle. I see him every day. He sees me every day. How is it that he is still possessing a driving license? To avoid these situations, the law says send a copy to the district magistrate. Unfortunately, no further action is being taken. Sir Vaishnava, that is why there has to be coordination. So I did not discuss further under this, either in your presence if the offence has been committed, or you are aware of the fact that yes, warrant has been issued, or I can issue a warrant under some criminal law. Your case, you can either arrest yourself or cause his arrest. That is why you have such, I would say, critical as well as solemn functions and powers. Aru Saina sir, now I'll straight away take you to a provision which has been vexing you, bogging you for a long time. And I might come back to a few provisions that are more relevant to Bandi also. In mostly Kabima पनि सरले नोट गर्नुहुन्छ, even सिक्किममा सबभन्दा बेसी युज हुने नै यो हो, section 144 and 145 sir. Do you remember sir, जब पनि assembly session हुन्छ, the learned district magistrate issues 144. Even if there is an apprehension of public order being breached, now 144 might not pose a serious problem for you because it's general in nature. It's an order issued to the general public. But 145 would pose a problem for you because though under the law it is for public order, maintaining public order, but it has in many cases the underpinnings of a private dispute. I'll explain. At 144, sir ko training ma, sir recommend training ma, you have read it umpteen times. In cases where in the opinion of a district magistrate, a sub-divisional magistrate, or any other executive, sir, ADC would sir, sir, say any other executive magistrate, I know, especially empowered by the state government in this behalf, there is sufficient ground for proceeding under this section and immediate prevention or speedy remedy is desirable. You are apprehending that public order might be breached. Such magistrate may, by a written order stating the material facts of the case and served in the manner provided under section 134, which is mostly through public notification. So paper ma already dinuncha, voice of Sikkim ma dinuncha, Sikkim Chronicle ma dinuncha. I have read it many times. Direct any person. Now this person should also be read as persons. This is singular as well as plural. To abstain from a certain act or to take certain order, so and so, which might be basis to annoyance, injury or now this power is also used by Commissioner of Police in Delhi. Like the executive magistrates or the district magistrates here, in Delhi and probably Chennai also, you'll see that even police commissioners are using this power because they have been specifically empowered to exercise this power under section 140. ESMA I need not go because practically you have been doing this during every assembly session answer. Now I'll come to the more trickier part of the law. Acha, time limit and all you know, I did not go into that. Section 145, सबभन्दा बेसी तपाईहरुलाई in districts, including in Gangtok sir. This is the provision where everyone would come under you. Not under you, sorry, come before you. I'll give you an example. दुईटा छिमेकीमा झगडा हुँदा पनि सर, even if there is a dispute between two neighbors, छिमेकी means neighbors, they will come to you. They're not sin. And even people whom I have known have gone to before the learned magistrates, executive magistrates. Now what does it say? We'll just read it together as a, whenever an executive magistrate is satisfied from a report of a police officer upon other information. Sorry, no say. Report of a police officer or upon other information. This upon other information could be your personal knowledge as well. Suo moto. Sir, sir, you see that some college students are vandalizing few vehicles, taxis, and for example, since you are seeing it, or maybe you have been informed by someone over the phone, you are to swing into action. That a dispute likely to cause a breach of the peace exists concerning any land or water or the boundaries thereof. Within his local jurisdiction, he shall make an order in writing, stating the grounds of his being so satisfied and requiring the parties concerned in such dispute written by pleader being advocate on a specified date so and so. Then copies of the notification serving and on the parties. However, now at a first glance, on a cursory reading, you might not note that unusual things which I am about to point. Keywords: cause a breach of the peace. So, can a fight of a personal nature between me and my neighbor, which takes place in Ranka, can it be of such a magnitude so as to be termed as breach of the peace? Absolutely not. So, हामीले के गर्दैछौं in Gangtok especially, and Soaring and Gyaltsing are other trouble, and Namchios. Simple boundary cases ma also you are applying 145. Please don't do it. You can tell them, look, but if it is of a bigger magnitude, त्यो दुईजनाको झगडाले गर्दा गाउँमै झगडा भइसक्यो, then the element of public breach of peace would come. That is for you to, you are the best judge for that. But only a fight between two boundary holders simply sit up. You cannot exercise this power. Your power can be challenged before a sessions court, not even the district magistrate, because before the sessions court, under revision power. And I have personally set aside such orders passed by the district magistrate. In 2015-16, such matters had come before me as the sessions judge. And I had to set up a drug company ko थियो. It was from your 32 number drug company some related. An order under 145 had been passed, which however was, the dispute was of private nature. So what you can do is, sir, whenever such cases come, first look at the public breach of peace element. If there is no such element, you can just say, no, you go to the local court. You cannot say the courts are closed. Or at the most, you can say, okay, for 3 days, maintain status quo. Till then, you go to approach the court. A court ma basic case of court le bhyaunदैन one something. That cannot be an excuse. Please note this. It has to have a public breach of peace element. Private peace ko हुँदैन sir. Private breach ko हुँदैन. It cannot be of private nature. Order the tabeli in good faith दिनु भयो. But what good is the order if it cannot even sustain before the next higher forum? So this breach of the peace are the keywords here. Kindly, यो चाहिँ हमेशा तपाईहरुले याद राख्नुपर्छ. Other procedural aspects I need not go. Then now, if you go to Gangtok MG Marg, and at one point of time, I have actually seen a London executive magistrate exercise this power. In MG Marg, sir, this provision, जो तपाईलाई एकदमै handy आउँछ. Sir, you हेर्नुहोस् है, often overlooked provision. Our London magistrates often overlook this provision, जबकि they have such powers also. Conditional order for removal of nuisance. For example, sir, अहिले कहाँ हुन्छ भन्नु सर? Gazing, sir is in Gangtok. For example, sir, you go to, let's say, you are taking a stroll in Gangtok MG Marg. You see a building which is dangerously being constructed, which is often done here. I'm sorry. Unload नराम्रो पाराले, scary पाराले गर्दैछ. As you know, ours is a hillside construction mostly. While excavating, डरलाग्दो dangerously गर्दैछ, property of the other parties, neighbors is likely to be affected. What do? We tell them, look, you go to UDSD department, now it's UDD, or you go to buildings department, or you go to court, or you go to the police. Police would immediately say, this is a civil nature, हामी के गर्नु सक्दैनौँ. But you as the learned magistrate, executive magistrate, sir, I'll just read it out first. Whenever a district magistrate or a sub-divisional magistrate or any other executive magistrate, especially empowered in this behalf by the state, and mostly all of you are empowered. There will be some notifications that some be empowered to functions, all functions under GRP. There is a especially empowered in this behalf on receiving a report of the police. Agar your police say, you might not be taking a stroll in MG Marg, the police might say, sir, this complaint has come, but civil in nature and under 133 application we are making. On receiving the report of the police or other information which could be your own suo motu, and taking such evidence. This need not be a trial wala evidence. Documents and what you see, photographs. That the construction of any building, I'll straight away come down, construction of any building or the disposal of any substance as is likely to occasion conflagration or explosion should be prevented or stopped, that any building, tent, structure or any tree in such condition that is likely to fall and thereby cause injuries to an and so forth. So this particular power under 133, I have very rarely seen being exercised. Sir, Kabi, after today's program, while going to Kabi, once you enter your jurisdiction, तपाईले देख्नुहुँदैछ डरलाग्दो रोड काट्दैछ, फरेस्ट डिपार्टमेन्टले काट्दैछ, but in a precarious manner. You are the boss. This is the power. And This does not mean only by public, by any other government departments also. When there was an earthquake here, Singtam ko अलिक माथि त्यो बिल्डिङहरु तोड्ने अर्डर भन्छ सर। त्यसमा अन्त हेफेजेटली तोड्नु खोज्दै थियो सबले। That is the time when such powers could have been used. Or for example, sir, that any tank, well, tank or excavation argument, sir, adjacent to any such way or public place of so and so, such manner to prevent danger arising to the public. Building bandai sir, and it's as if that scaffolding has opened some asko lagako sir, likely to fall. You will have to, you can accept, you need not go to other police. CrPC itself, though it is only a procedural law, here it actually provides for the substance also. Esto matter happens. So this is where 133 gives you such a wide power. And dangerous animal. Kahi bhai ekdamai ferocious dog छ के छ त सबैले त्यसमा पनि sirs can always look into it.
So in single lines can be imposed for public safety.
Sir, public safety, public order, public breach of peace, will be your keywords. That's the third rule. Without that, you cannot act. You cannot act for two neighbors. That's private in nature. Let them go to the court. What's sir? Public co character. For example, sir, I know in districts, sir, हेर्कोमा केस कस्तो आउँछ भने two types सबभन्दा बेसी आउँछ सर। फरेस्टको सर्वेमा नाम गयो मेरो जमिन या उसको नाममा मेरो सर्वेमा मेरो यसकोमा नाममा पसेछ खासो मेरोमा पोजिसन छ। अर्को तपाईको बाजेको सम्पत्ति दाजुले मात्रै लग्यो सबै नाम सारी उसको मात्रै गर्यो। These are the cases which we have. Now in none of these public breach of peace would actually be involved. Of course, if it is at a larger scale, then sir, your power is you need not go through any other law. 145, 133, 144 also. You can derive that power from these three provisions. Or just a public orders, I am not going to it because these are the key provisions. And only since we started late in the hope of having more magistrates, there's a time and I have another session today. Now, these three key provisions तपाईहरुले याद राख्नुहोस्, and I also wanted to discuss. So normally what happens is, if it is a course for lawyers, law students or judges, then we give case laws also. So that उहाँहरुलाई जजमेन्टमा काका कोर्टको अगाडि हुन्छ। तर सरहरुलाई त परेन। अलिक रिल्याक्सेसन सरको कम्पेयर टु दैट। एउटा चाहिँ म ब्रीच अफ पब्लिक बन्ड हेर्थेँ कि सर एकछिन। Sir, you must have noted, sir, mostly in West Bengal, in Delhi also, sir, you see that Ramlila Maidanma ke garnu आटेको छ, some bond was taken. Sir, if you look at the news in detail, this provision, हेर्नुस् sir, relating to property public breach 144, sir, like keywords राख्नुस् न, 144, 145, 133, 107. Very nice provision. When an executive magistrate receives information that any person or persons, this is plural singular, is likely to commit a breach of the peace or disturb the public tranquility, or to do any wrongful act that may probably occasion a breach of the peace. So, public peace की कुरा हुँदैछ sir. and is of the opinion that there is sufficient ground for proceeding, he may, in the manner hereinafter provided, procedural aspects of the require such person to show cause why he should not be ordered to execute a bond with or without sureties for keeping the peace for such period not exceeding 1 year as the magistrate experienced. So this is again one provision. Before elections, you must have seen learned district magistrates ordering people to surrender their arms, or if not arms, asking them to execute bonds. जो अलिक bad character भन्छौँ हिस्ट्री सिटरहरूलाई उनीहरूलाई बन्ड हुन्छ तडी पारेर भन्छ नि सर त्यस्तोलाई अलिक बन्डहरू एक्जिक्युट गर्नु लाउँछ. It is under this provision. It is not only the district magistrate, executive magistrate. And what an executive magistrate can do, district magistrate can obviously do, because he is above them. हुन्छ सर? This particular provision within your jurisdiction, sir. Kabhi you see elections आयो, you are the election officer, some nodal officer or something. Or even as magistrates, you see that no, this guy or this particular group is likely to create nuisance in the coming elections. This is the provision. You don't need any other source for deriving this particular power and function. Okay, sir? 107 is also a very key word. And sorry, what I would advise is whenever you write any order, sir, whether on the criminal side or on the civil side, हमेशा कोशिश गर्नुहोस् so that you give reasons for that. It should be a speaking order, भन्छौँ sir हामी. All your orders, sirs, should be a speaking order. Because what if your order is challenged? It can be challenged before London district magistrate or the state government department or before the court. The court will also see that no, the London magistrate has given these reasons. It's a speaking order. It is not a Jimny order. A Jimny order भन्छ हामी. छोड्नु कि हर पार्टीज order दियो. Hard parties ले यस्तो भन्यो, B said so and so, I've gone through the, I've given my thoughtful analysis, consideration to the rival submissions placed before me. Document A talks about this, it has been properly signed, something like this. It has to be speaking order. That's the key to your तपाईँको order. कसैले, it will be unassailable. It cannot be challenged. So please make it a point. And I've told all the learned magistrates over the period of years, speaking order. I have seen district magistrate Mangan, Mr. A.B. Karki, give one order without any reasons when he was SDM. I have also seen Mr. Hemant Rai, they are very good friends of mine. And Mr. Hemant Rai was AD, give an order without any reasons. Once I pointed out to him, he has started giving very long orders. Vishnu sir, someone had to point it out. And it's a casual conversation, I told him, and after that I saw all his orders. जब वहाँ ADC gang to गए थे, it was very long orders. तपाईँले हेर्नुहोस् त. And that's the right thing to do. Speaking order, good faith. At one point of time, sir, few years back, somebody asked me, you do so many kachade cases, होइन? यस्तो case, murder case पनि गरिरहेको छ, corruption case also, so and so. How do you sleep at night? I said, I don't know. When I feel sleepy, I go to the bed. Bed was ढल्केको त निद्रा लागिहाल्छ. There's a reason for that, because I know whatever I have done, I may have gone wrong in few places, but at least I have done it in good faith. बुझ्नुभयो sir? Good faith मा गरे, I gave reasons. I may be wrong. I am not the last court. होइन sir? माथि कोर्टले set aside गर्छ, Hon'ble High Court will set aside. Hon'ble Supreme Court is there. But I can sleep, म mistake गरेँ in good faith. There was no law on that, but after deducing everything, researching, I have given certain opinion, given reasons for that opinion and that decision. त्यसो गर्दा in good faith, speaking order, nobody कसैले केही गर्न सक्दैन sir. That's the key. Especially young officer, that's the key. Now sir, I'll take you to a provision where not only you but even the judicial magistrates are concerned, directly concerned. I'll go to that provision. Section 174. I'm sure those who are seniors here, सरहरूले कहिले न कहिले यो custodial death, be it in the police station, be it in the jail, हस्पिटलमा पनि हुनसक्छ, मेन्टल एजाइलममा पनि हुनसक्छ, चिल्ड्रेन्स होममा हुनसक्छ, ओल्ड एज होममा हुनसक्छ, where some unnatural death or foul play is suspected. Suicide केसमा not only custodial violence but suicidal death. I have done many inquiries in custody मा सुसाइडहरू भएको, सिन्ताम थानामा भएको, नाम्ची जेलमा भएको, अस्ति यही माथि पनि भएको, त्यो त मैले डाइरेक्टली गरिनँ, under someone under me. I'll just read it out. When the officer in charge of a police station or some other police officer, especially empowered by the state government, in that they have received information that a person has committed suicide or has been killed by another police custody man, or by an animal, balu ko attack, bake ko attack, band is suspect, or by any machinery. It could be in these drug companies, any company, factory, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offence, he shall immediately give intimation thereof to the nearest executive magistrate. Empowered, you all are empowered to hold inquests. This is one difficult thing for you. And unless otherwise directed by any rule prescribed to order of the district or the sub-division, shall proceed to the place of the body of so and so. Now, the following magistrates are empowered to hold inquests, namely district magistrate, SDMs, or any other executive magistrate. Especially empowered, like I said, all of you are empowered, not only by the state government, but the district magistrate will be empowered by the audits. This is one thing I had not noted. Now, sometimes the police would also do some inquest, but that doesn't mean that you are not to do it. सरले गर्नै पर्छ. And सर यहाँ छ अघिको चाहिँ पुलिस has to inform you immediately when there are reasonable suspicions. Under one, that was 174. Under 176, you are also to hold inquest. Understand? When the case of the nature referred to in clause 1 or 2 of Ogiko section 174, the nearest magistrate empowered to hold inquests, and in any case to so any magistrate to empowered, we are holding inquiry into the cause of either instead of in addition to. मैले भने सर, police would also do it, but in addition to, तपाईले गर्नै पर्छ under this clause. Investigation held by the police and executors, and you can come to an independent finding bite marks होला, which the police officer might not have noted. And normally police calling the lopsided हुन्छ. They would either want someone to be guilty or not guilty. Yours would be more about, like I said, quasi-judicial functions. र आजकल चाहिँ के छ सर, in when it comes to custodial death, even the judicial magistrate judicial magistrate got. So there would be at times 3 inquest reports by the police, more of elementary in nature, by the learned executive magistrates, and also by the judicial magistrate. No, take it, sir. No harm in that. No, you thoroughly open that. Now, apart from that, सर इनको रोल होने चाहिए. Something which will come before you again and again is section 83. Sir, I'll just give you a background. There are 2 provisions, 82, 83 ones, sir. These are very frequently used by criminal courts. Now, what is 82, sir? I'll just give you the background. Suppose you are accused, sir. If he is absconding already since the beginning, crime hone bitika he has been fleeing from justice, or maybe he was taken in custody by the bail or a bhagyo. Answer? Yeah, custody wada aafila. In these 3 cases, sir, we issue warrants. Police le charge sheet submit garcha, absconding charge sheet bhancha हामी. Okay, accused se bhagyo, Nepal bhagyo, Bhutan bhagyo, or Bihar tira bhagyo, Bengal tira bhagyo, absconding charge sheet. Now it comes before us, before magistrates, judicial magistrates, or chief judicial magistrates, or POCSO in the sessions court, or special court. What we do is, sir, as a formality, now we know that he might not be found. We issue a warrant again. हाम्रोमा चार्ज शीट फाइल भएपछि हामी एकै फेरि वारेन्ट पठाइन्छ. That warrant goes to either that IO or to the officer in charge of the concerned police station. Outside state over through IO ne पठाइन्छ. And the local police will normally coordinate and cooperate. Warrant comes back. What does it say? Despite thorough search, due search, he could not be accessed to, so he could not be traced, so the warrant could not be executed. ठीक है sir? Then we call that OC, officer in charge of the police station, or that IO, or anyone just warrant लेकर गएको थियो. We examine him under oath. कसम खानुस्, कसम खायो. Okay, so you went there? Yes. I went to gazing, but I could not find him. Correct? He'll sign and go. Now what we as criminal courts would do is, warrants are iron, sir. So we issue a proclamation. Proclamation, public proclamation, that will go usko ghar ko area mein. Suppose for example, if he is from Singtam, Gangtok Court Singtam, तो उसको घर को दैलोमा टाल्छ एउटा. Whereas Mr. So and so accused is accused of committing an offence and whereas it has been shown to my satisfaction that he cannot be found or has been absconding, due to which the warrant issued against him cannot be executed. Proclamation is hereby made that Mr. X shall come to the court on 1 महिनाको time हुन्छ at 10 AM and answer to the charges against him. In 40% cases, those people come. 40% cases, those people come, and we grant bail also. Sometimes they say, "Arey, warrant issue, I had gone to meet my relative in Tamil Nadu." They will say that I was not aware of the warrant. And we also see that after all he has come. If it is serious offence, then we don't. But normal offence, 303, grievous hurt, injury, we grant bail. Now what if he doesn't, that proclamation ko baad mein aaya na? Till now you have no role as executive magistrates. A proclamation after 1 month ko and he doesn't come. Then we issue a process. So process भनेपछि के हो भने sir, people get confused. Process भनेपछि warrant, summons, notice, or anything which you issue from the court is called process. Proclamation, attachment order, civil case, all these are processes of court. Understood, sir? Oh, I have issued a process against you. That process could be warrant, summons, proclamation. Process by way of summons, process by warrant. Sir, these are court processes. People tend to get confused. So now, warrant go, he did not come. Proclamation go, he did not report. Only option left to us is issue a process, that is attachment order under section 83. Now what happens is, under section 83, हामीलाई situation problem हुन्छ उसको गाडी उसको नाममा गाडी छ कि छैन, property, immovable property, land, building. If he is a salaried person, we even attach his salary. Now if it is an immovable property, then your role comes. यहाँनिर हेर्नुहोस् सर, section 82(2) हो यो. Such orders and authorize the attachment of any property belonging to such person within the district in which he is there, and it shall authorize the attachment of any property belonging to such person without such district, when endorsed by the district magistrate within whose district such property is situated. If the property is ordered to be attached, the date and whole property, the attachment and so and so, this can also be done. So the moment we say district magistrate, it matches together. The court issuing a proclamation under section 82, जो I know, for reasons to be recorded in writing at any time after the issue of the proclamation, order the attachment of any property, movable or immovable, or both belonging to the proclaimed person, that accused person, provided that where at the time of the transfer. Now this attachment order is invariably issued to the London district magistrate or the concerned subdivisional magistrate. Just so in that copy, there is no district magistrate, so we send it to the subdivisional magistrate or ADC if he has jurisdiction. Now, if the property ordered to be attached is immovable, the attachment under this section shall, in the case of land paying revenue to the state government, be made through the collector of the district, subdivisional magistrate or subdivisional collector. के भन्नुहुन्छ? बंगालको subdivisional officer भन्छ, SDO. So what we do is, for example, if the land is in Kavi, हामीले attachment order Mr. X जो accused छ, उसको property नाम छ यहाँ. It could be his ancestral properties also. It may not be in his name. It may be in his father's name or grandfather's name. So what we do a symbolic or a notional calculation. कि यति चाहिँ उसको भाग पर्ला. We ask the family members. They cannot say कि no बन्डा भएको छैन भने. We take it notionally, attach it, board sort लगाएर हुन्छ. And believe me, in 80%, okay, I said 40% proclamation, 80% they tend to come back. Family members ले भलाइहाल्छ. That is why property को कुरा छ. यहाँ चाहिँ तपाईहरुको रोल आउँछ. As magistrates, executive magistrates, and also of the district magistrate, this is where your role will come. You will have to send, of course, तपाईहरु त जाँदैन. You will send your army or RO. They will submit a report. At times, के हुन्छ अमीनहरु ROहरु सिक्किमको I don't know, but सिक्किम बाहिर most बदमाश हुन्छ. They will give a false. So please make sure that you send someone. या आफै पनि जाँदा हुन्छ. If you can make out time. र property मा जानुभयो, meet the family members. अब property छैन भने त कुरै गइहाल्यो. This is only when the property is there. Then property documents हेर्नु पर्यो, सबै गर्यो तपाईहरुले. Then you will pass an order saying that yes, we have taken possession. मतलब what? That doesn't mean कि तपाईले त्यहाँ टेन्ट लगाएर बस्नु. For example, Ranka forest is under the possession of the state government. That doesn't mean state government has deputed someone. त्यहाँ कुतियादार आएको त छैन. It's a understood constructive possession of the. So what you do is by taking possession by appointment of receiver, you can appoint the local BDO. भाई यहाँ तिमी इंस्पेक्ट गर्दै गर्नु. इसको कुतियादार जो छ, अगर वहाँ पे कुतियादार वगैरह छ, शेयर क्रॉपर या whatever, let them deposit the rent with you. They will not deposit the rent with the house owner. With you, तिमीले बैंकमा हाल्नु. By an order, I think prohibiting payment of rent, यही कुरा. By all or any two methods, as the court thinks. This court is obviously you. तपाईहरुले त्यसरी प्रपर्टीलाई एट्याच गर्दा हुन्छ. यति मेन रोल तपाईहरुको अन्डर CrPC छ. These are the main roles. Like I said, 144, 145, 174, 176, 107, 133. I understand? Your key function, what I would say, sir, is not separate. Tell me, what is beyond your scope? Sir, that is why SDM has such aura and majesty to its office. Sir, colleague, if he is only posted as Joint Secretary, Education Department, he won't have that aura. But the moment you come as magistrates, this is the reason. Property also tabereke cha. Public breach peace tabereke cha. Law and order tabereke cha. Attachment of property under criminal law tabereke cha. Civil ma ta chha cha tabereke. That is why it was important for all the learned sub-divisional magistrates to attend this program today. Now, under CrPC, I did not go further. Unless, sir, anything. I will discuss because I have 10 more minutes. Sir, anything. Till now, or beyond that also. Sir, confusion by time declaration, at times, sir, what happens is, suddenly, surely in Kabi, surely in Gyalsing, and surely in Ganto, you might receive a call. Sir, jhagda bhayo sir, या ब्राइट बर्निङ केसमा सिक्किममा त हुँदैन ब्राइट बर्निङ बट समटाइम्स सर्टेन पिपल डु इट. बुढीलाई जलाएछ, मर्नु आँटेको छ, अस्पतालमा तपाईँ आइदिनुहोस्. तपाईँ जानुभयो. What you will have to do is first, doctor, where is the doctor? Please come here, doctor. What is the mental state of this victim? The doctor has to certify the mental state. Doctor will say, yes, 80% burn, sir, but mental faculty is working. He or she can answer or give his or her statement. You will record that as per doctor's statement, he is in a fit state of mind. Certificate पण बात बनाउँदा हुन्छ doctor को. Then you start bistari के भएको थियो, he will say. In many cases, our magistrates have recorded such dying declaration. Then, under SADA NDPS मैले भने, that is again a very vexing area for you. Especially those who are posted in Gangtok, Gazing Bazaar, I don't know much, sir, but those sub-divisional magistrates who are posted in Jorthang, Rangpo, Gangtok, Singtam, Malli, Naya Bazaar, they will have a field day with SADA and NDPS cases. Rati phone आउँछ, magistrate sir, आइदिनुहोस्, suspect पक्रिरहेको छ. We have detained him in the police custody or detained him in the spot, in the market. Please come, भने तपाईं जानुभयो. So that, then you will have only, I would say, ministerial functions there. Nothing much. But you will have to be available. Because if you are not available, then some gazetted officer go. And what the police do is, police ke gazetted officer, that will make the case weak. That is why your independent role should be there. So excuse me, my phone over here. Hello. Yes, go on. Yes, what is this, sir? Sir, so, and under civil law, sir, Under CPC, you have so many functions. Attachment of property, like in criminal cases. Then registration of documents, I did not go into that as a mostly civil mateo. One thing which I have noted is, I have not seen any subdivisional magistrate or the sub-registrar impounding any document. Very rare. I have also not seen our magistrates, executive magistrates, looking into the stamp duty. Khatiwada stamp, now the rules are much better. Till few years back, it was very difficult. Kati stamp duty, Kati stamp paper, what would be the fee? That was not clear. Now, I think after that 2016-17 notification, everything, if the document, if the deed is for 80 amount, this will be the stamp duty. If the deed is for this amount, is money charge. That gradation is there. So, tabayarly, you will have to see before registering the document whether everything is there and whether the stamp duty has been paid by the party who is to pay it. You sabai herera matra tabayarle act गर्नुपर्छ. अर्को what I have seen is in the registry, especially the sub-registrars, that book of registration, the charter book mentions, that is not properly maintained. I have seen cases where they have actually challenged the registration proceedings based on that. And these are very kachore cases. I decided the matter is before the High Court now, sub judice, so I will not discuss further. So you should pay. Nothing doing Sikkim registration of document rules ma, 1930 ma heर्नुहोस्. It is not a complicated science course subject. It's a simple, certainly heर्नुहोस्. Why? Because if something goes wrong, then at times even criminal liability could be there. I'll give you an example. In Siliguri, not Siliguri, Alipurduar somewhere, COVID period ma, there was one mutation done. There is no record of public notice, no record of deed of conveyance, not even the chain of documents had been changed, chain of deed documents, so not even that was referred. And the concerned sub-registrar mutated the land. It was challenged. Now that sub-registrar is facing a criminal case because it is a clear case of 420 and forgery. State government sanction bande wala hai, Bengal government. So let us be careful of these things. That is why I said by the book and good faith. Okay, sir? Sir, त्यतिमा sir anything? मैले भन्नुपर्ने यति नै case laws sir, like I said, sir, these case laws would say if it is private in nature dispute, don't apply that public breach wala. These are all disputes, it won't be that good for you. Sir, anything or anything which has been concerned, vexing you, sir?
So even sir, notification, sir, 1 month notice to cancel, sir.
Sir, janai parcha, it has to be a public notice, and
Yes,
even relatives will shop, and you can also send
yes, sir.
individual notices also, sir. So you have to be careful, sir. Jabaki, and let me tell you, Sikkim registration of document rules gives you the discretion to issue public notice, which is not in other registration rules. If the sub-registrar considers it necessary, bhaneko cha. But still you've been sending public notice. So imagine that West Bengal case, and you won't believe the land belongs to ACGM Siliguri. I meet him during protocol duty, so we're discussing that. You have to be very careful, sir. Sir, any queries, sir? And subject is such that director you will be knowing more than me because you've been practically using it. I am the theoretical knowledge sir. Plus alikati euta provisions guide gardinu matrai jasto katiwada we know that it is in the CrPC, but which provision we don't. त्यही मैले जो key sections भने सर त्यही मात्रै सर.
So for reference, I think I would appreciate
CrPC.
So whatever we have discussed, we made component of the section which pertains to our jurisdiction and our execution of the flood within our jurisdiction. So we would like to have those
Those provisions only. Those say. So what I can do is, पहले land acquisition को मेरे एक दूसरा pending है सामने magistrate साहब लगे जिनको करने की. I'll not in सारी चीजों तो बेहोने ना सर की. मेरा तब एक दूसरा committee report है सर. What I can do is I can share with the director only those provisions which are relevant to you.
Yes.
Yes, sir. Yes, sir.
त्यो गऱ्यो एक दुईवटा comments with judgment हाल्दियो, होइन सर? त्यो गरेर एउटा handbook for executive magistrates भनेर start गरेर compile गर्ने अब नाम त हुनै पर्यो compile गरेपछि I can do that. That next step.
Only this copy paste and the one soft copy will do so.
So I'll do that. Not your training ko लागि भनेर I'll do it otherwise also, sir. And I've been doing this also. I give lectures pan India, online, offline. So I've written many books, sir. Articles, and this field is something I certainly manda. I'll make a handbook for executive magistrates. Give it to the academy at their expense. Let them share. Sorry, I remember there's a handbook for district magistrates. Is there a handbook for executive magistrates?
No, sir.
I'll make it, sir.
So during election time, just for precautionary preparatory exercise, we are given that CrPC.
So that is only related to election summary.
Elections. So small extracts are.
So what I can do is,
Section
sir,
121
so what I can do is, registration rules ko halyo, every field mutation ko bare ma halyo, right sir? Civil criminal board. It's a very as it was supposed to be, no sir, it will come. What in fact, my keep it, but sir, at one point of time, Hon'ble Honorable High Court ko all notifications. I am in High Court only since July 1st, sir. Even the oldest of notification I have compiled my own copy. And I had given it to the previous director here, I don't know what she did. And I don't know whether it was circulated to other judicial officers, I'll ask her. But even a rare notification copy I had. And district ma mathe, High Court or district ma mangte copy. So do you have a copy here? Because if I don't find it, matlab, nobody will find it, sir. That's another reason. So your handbook, sir, I'll prepare it. Because there is no mirror role side, I'll just have to tell my stenographer. Type from here to here, only give space for my comments in case. Again, another book. Type from here to here and my comments and judgments. This is mirror role side, sir. Just to have your committee rules, one of them, sir. Just a criminal practice rules that was actually drafted by me. त्यसमा पनि अब मैले एउटा पनि वर्ड टाइप गरिनँ. डिफ्रेन्ट स्टेट्सको हेरेँ, सुप्रिम कोर्टको जजमेन्ट्स हेरेँ, सबै कम्पाइल गरेर हाल्दै थियो. नाउ इट इज रुल नोटिफाइड बाई द स्टेट गभर्मेन्ट एन्ड फुल स्टप कमा आई हेभ पुट. एक ठाउँ रङली कमा पुट गरेर त्यही आएको छ. सो आई प्रिपेयर अ नाइस ह्यान्डबुक छ एन्ड त्यसको उ चाहिँ गर्नुपर्छ. वी विल ट्राई एन्ड बुक लन्च गऱ्यो through either the director or higher level. Chief Justice साहब पढे पनि यहाँ हुन्छ या हैन, त्यो गरेर we'll do it and state government officers can go through it. All those who are posted in magistracy.
That will be really reference book for executive.
Sir, no, sir, I will take your sir बढी कुरा निस्केर आजै भएको यो म गरे यो something which I personally मलाई बुझे गरे. And there is nothing much to do, sir. खाली इलेक्सनसँग रिलेटेड पनि हालिदिन्छु. अलमोस्ट अल एसेन्सियल कमोडिटिजमा होइन, फिमेलसँग रिलेटेड, किड्सहरूसँग रिलेटेड हालिदियो कि सर. इन्डेक्समा हेऱ्यो विथ रिगार्ड टु चिल्ड्रेन, डक्टर चाइल्ड लेबर यता हेऱ्यो. सर मैले किताब पनि देखिसकेको.
Senior Citizens Act is also there.
द्याट इज अल्सो देयर, सर.
Disabilities Act is also there. RPWD, because there is also a big role in the magistrates and district magistrates.
Persons with disabilities.
Yes, RPWD Act 2016.
अब the adoption पनि I think district magistrate पनि छ, सर. So you have such to do. In the future मा त सरले पनि district magistrate हुन्छ प्राय. So you have that role. सर सरलाई अरू केही चाहियो सर
So,
But I will take your ideas.
and actually whatever we have learned, just
Sir, you have not learned anything. I only refreshed your memories. सीधे कुरा Ma'am, we are done here. Sir, anything you would like to ask, sir, before we wind up? Anything, कोई भी matter.
I have a handbook for executive assistants read by academy. Can I show you?
You have that?
Yes, sir.
यहाँ का academy?
No, from ISA.
अच्छा अच्छा अच्छा. Sir, उसको क्या PDF में है क्या?
हाँ, sir.
Please take my number and forward it, sir.
Okay.
I'll refer to that also. Sir, please take my number. Sir, give me your number, sir. है ना? ये WhatsApp से नहीं आएगा सर?
हाँ, sir, I will send it.
आपका नंबर दीजिए सर. The one which has WhatsApp.
Yes, sir. 8010.
Yes, sir.
80 4494.
So we've come to the end of today's
सर,
session.
आपको एक WhatsApp भेजा है. उसी में मेरे को भेज दीजिए. Okay. I just go through it.
Uh, I'd like to request all our participants and our learned resource person to gather at the quadrangle for a photo session and then the banquet hall for lunch.